Hey everyone, and welcome. Today, we're stepping inside the courtroom, but we're going to approach it a bit differently, like we're solving a puzzle. Our mission is to piece together one of the most fundamental ideas in law, the difference between something called a fact in issue and a relevant fact. Let's dive in. Think about any courtroom drama you've ever seen. There's just a storm of information, right? You've got witnesses, alibis, motives, accusations. It's a lot. So, how on earth does a court cut through all that noise? How does it decide which bits and pieces actually matter in the search for the truth? That's the core problem we're tackling today. And honestly, the best way to get a handle on this is with an analogy we all get, a jigsaw puzzle. Before you can even think about putting it together, what's the first thing you do? You sort the pieces, right? You find all the edge pieces, you group the colors, you figure out what's what. Well, it turns out the law does the exact same thing with facts. So before we can assemble our legal puzzle, we first have to understand what the pieces themselves even are. What does the law actually consider to be a fact? It's actually a little more specific than you might think. Okay, so legally speaking, facts get sorted into two big buckets. First, you've got physical facts. This is pretty much anything you can perceive with your five senses. An object, the state it's in, where it was found. For example, the fact that a knife exists is a physical fact. The fact that it was found at a crime scene, that's also a physical fact. But then you have psychological facts. Now, these are the things you can't see. They're all about what's going on in someone's mind. We're talking intention, motive, knowledge. Did they mean to do it? Did they know what would happen? These are absolutely crucial to any case. All right, now that we know what our puzzle pieces are, let's look at the most important part of the whole thing, the main picture on the box. In the legal world, this is what we call the fact in issue. A fact in issue, or factum probandum, if you want to use the fancy Latin. These are the absolute core questions of the entire case. You can think of them as the hills that the prosecution must conquer to win. Put simply, if these questions don't get answered, there can be no verdict. Period. Let's make this really concrete. Say we have a murder case. The court doesn't just ask, is A guilty? No way. It asks a bunch of super specific questions. Things like, did A actually cause the death? Was it an accident, or did A intend for it to happen? Was there some kind of provocation involved? And was A mentally sound at the time? Each one of these is a fact in issue. The whole case lives or dies on the answers to these questions. So, if the facts in issue are the main picture, what about all those other puzzle pieces? Well, those are the framing pieces, right? The edges that give the whole thing structure. In law, these are called relevant facts. A relevant fact, or factum probans, is basically a clue. That's the simplest way to think about it. It's not one of those ultimate questions itself, but it's a piece of information that's logically connected to one. Its entire job is to help the court answer a fact in issue, one way or the other. Let's jump back to our murder case and see this in action. A long-standing feud? That's not a fact in issue, but it sure points to a possible motive, which makes the question of intent more interesting. A was seen buying a knife? That doesn't prove murder, but it definitely shows preparation. And what about A fleeing the city right after? That suggests a guilty conscience. That's revealing conduct. And of course, an alibi? That's a huge relevant fact that points in the complete opposite direction. See? Each one is a clue, pointing either toward or away from one of those big questions. Okay, so we have the main picture and we have the framing pieces. Now it's time for that satisfying click as we snap them together and see exactly how these two concepts are really just two sides of the same coin. So let's just lay it all out, side by side. Our puzzle analogy? The fact in issue is the main picture, the relevant fact is an edge piece. Their role in court? The fact in issue is the ultimate question. The relevant fact is a supporting clue. Our example? Did A intend to kill B? That's the question, the fact in issue. A bought a knife beforehand. That's the clue, the relevant fact. And of course, you've got the formal terms, factum probandum versus factum probans. But this brings us to what is probably the single most important rule in this whole system. Think about one of our clues for a second. The fact that A bought a knife. By itself, does that matter at all? If you take away all the other context, is that a relevant piece of information? The answer is a clear, absolute, 100% no. A fact can't be relevant in a vacuum. It's just not possible. So here's the golden rule. Relevance is all about the connection. Buying a knife is totally irrelevant noise until you connect it to a fact in issue, like, did A cause B's death? Without that link, it's just a person shopping. With that link, it suddenly becomes a potentially powerful piece of evidence. That connection is the glue that holds the entire legal puzzle together. Now that we've built our puzzle and we see how all the pieces fit, let's step back and look at the finished picture. Why go through all this trouble? Why does this distinction actually matter so much in the real world? Well, it all comes down to three huge benefits. First, it creates focus. It stops the court from getting bogged down in tons of useless details. Second, it ensures fairness. It filters out info that might make someone look bad but has zero to do with the case, which prevents prejudice. And finally, it demands logic. It forces everyone to build a clear chain of reasoning, following the clues, the relevant facts, to arrive at an answer for the ultimate questions, the facts and issue. And that really is the bottom line. This whole system, this distinction, it's the bedrock of evidence law. It's designed to make sure that justice is based on a logical structure of proof, not just a random pile of information, or worse, feelings and biases. It's what brings order to the chaos. So I'll leave you with a final thought. Now that you've got the framework, put yourself in the judge's seat. In our case of A and B, what other clues might come up, and how would you decide if they're actually relevant to those core questions? It's a puzzle that judges and lawyers have to solve every single day. Thanks for digging into it with me.